Yo, 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 what's good, beautiful people? How y'all doing out there? Peace, love, and law to everybody, and everybody's having a great and beautiful day, man. As always, welcome to In God We Trust Academy podcast, and we give thanks for your participation and just for you being here, and got some things to talk about today. How powerful is the trust, and how many of you got security agreements? Yeah, how many of you out there have security agreements? We want to know today. So we're going to get a little bit of that as well too, man, and just trust administration and how powerful everything is when you do things a certain way. All right, so we're going to talk about that tonight, man. Drop some ones if you're with us, man. Let us know where you're listening from right now, where you're tuning in. We're going to explain some things to you guys about your life estate, your straw man. Going to talk to you about trust and just fully administrating and how to deal with courts and things of that nature and understanding what it is when it comes to the commercial realm of things and also when it comes to the practical common law of things. So we're going to talk about both. All right. And give you guys a deeper understanding. And then if you like what you hear tonight, maybe you'll want to come on and join us July the 26th. So let's jump into this, man. First and foremost, July the 26th, we do have a trust administration class, which is what you're going to hear pretty much a lot about tonight. And it's going to be in Fort Walton Beach, Florida, near Destin, Florida, that is. And it's live stream and it's also in person. So which whenever you choose to do is totally up to you. Does not matter, but being a part of this, and you're going to find out why tonight. So if you stick around long enough, you're going to see why this class for you is going to be so important. All right. It's $200 for the live stream. In person will be $250. The last day to register for live stream is Friday, July 25th, and the 23rd for in person. So you can go to www.ingodwetrustacademy.com and you will see the trust administration class there. Also, August the 9th, we'll have another class in Houston. So those of you who want to come out to Houston, Texas, learn how to operate on the hidden ledger of the bank. And that's literally meaning learning how to gain your equity through all transactions that takes place in the bank with your money. And that's pretty much what you're going to learn, how to go and claim that on with the IRS and things of that nature too, right? But we'll get into that later. But let's talk about it though. So when it comes to trust, right? Trust, I can tell you everything is pretty much trust, right? When you got the Constitution itself is trust. When you have the court rules or trust, or just even creating your own trust. Every contract is a form of a trust. Things of that nature, right? So to get down a little bit more with you guys on this particular level, where we're coming from today is the private trust administration class. And what this class is literally going to teach you is literally how to operate. Because a lot of people got trust, but it's going to teach you how to operate with the trust, your UCC, your security agreement, whatever that you have in your power that is for your trust, how to use and leverage these particular documents. Because a lot of you guys have it, but you don't know how to leverage. And I mean leveraging your UCC with banks, learning to leverage it with other third-party creditors, etc. Learn to leverage your secured interest in court. In courts as well. When you go and they have bid bond, performance bonds, things of that nature, forms of surety bonds, even appeal bonds, anything that is literally creating a form of is doing monetization based upon your energy, time, etc. That's being placed, right? And just learning how to fully go and take control of that is for one thing. Commerce. This when you think commerce, you got to think of literally first and foremost, anything can be sold in commerce. Literally anything can be sold in commerce. Just a thought. You can have a thought. You can sell your idea to someone. So intangible property definitely can be sold. Your time is considered private property. That particular private property can be monetized as well. So you can give your private property time. You can transfer your time to the trust. The trust now becomes the full ownership of your particular time, and now it has the right to leverage that time and value that time as it may see fit. All right. Same thing they can do with anything else that you might have. So you can take your body, right? You can place stats, you can place all energy, etc., that you may have, what I like to call your human capital. Place your human capital fully into a trust. And once you establish with this trust, you can also do what you call a security agreement with this particular trust for its administration and protection, et cetera, over the assets and property that you're going to grant to it, right? So now, and in collateral, you give it back. You give it everything, right? So now all of this stuff becomes collateral of the trust, right? So when that happens, oh man, that's where we're gonna start at with you guys today, because I want you to understand about your security agreement. And this is going to help you understand. Because if you don't know this, what I'm going to speak on today, more reasons to why you need to be in that class. And if you're listening today and today only, you're going to get a very special discount if you make it through the full class. So how about that? All right. So let's talk about it. Lawful execution of security agreement between the trust and the straw man. So, in the administration of a private express trust, it is essential to recognize and utilize the legal distinctions between what you consider the natural person, the trust entity, and the legal fiction commonly known as the straw man, right? So we're going to outline this fully with you in a security agreement between the trust, which is the secured party creditor, and the straw man, which is the debtor. Okay? We as the living are always going to remain and operate as the trustee. That is what we want to do. Trustee, beneficiary, right? We're going to make the straw man grant every single thing that it has or tie into the trust either by granting or it's considered collateral under the security agreement. So we got to know under UCC 1-201B27, it defined person as individual, corporation, business trust, estate, trust, partnership, limited liability company, association, joint venture, government, or any other legal or commercial entity. Okay? Straw man, in other words, which is your legal fiction, is the all caps name used on the government issued documents such as the birth certificate, social security card, and or driver's license. It qualifies as a commercial legal entity under this definition. It is capable of owning property, entering into contracts, and being a party to commercial transactions, including granting security interests, right? So this straw man can do all of that, just like a living being. So think about that. So the trust, when properly constituted as a private express trust, is also recognized under UCC 1-201B27 as a person, and therefore the trust has full capacity to enter into lawful contracts, acquire collateral, act as secured party in commercial agreement, and establishing security agreement. What is a security agreement, right? You ask. So under UCC 9-102A73 here, guys, security agreement means an agreement that creates or provides for a security interest. So this agreement creates an enforceable rights in favor of the secured party trust over assets held or titled to the debtor. So it's either held or title. So requirements for validity. UCC 9-203B. A security interest is enforceable against the debtor and third parties only if all the following are met. Value has been given. The debtor has rights in the collateral. The debtor has authenticated a security agreement that describes the collateral. These elements from the bedrock of lawful enforceability, each is explained in turn, which is value given, right? So the trust as secured party gives value in form of what? Protection. So the trust is going to, this is the consideration, give protection, administration, and assumption of liabilities for the straw man. Under UCC 1-204, value is defined broadly and includes a binding commitment to extend credit or forbearance. So that's exactly what we're going to make the trust do, okay? So the straw man as a public legal entity holds legal title or claim to property such as bank accounts, license, registered property, vehicles, real estate, etc., future wages, or even entitlements. Thus, it meets the condition of having rights in the actual collateral. Now, it has to outright fully have a right or interest in something, and it can be transferred. So make sure that we truly understand that, right? Now, what we're speaking on for those who just showed up, this is about having a security agreement with your trust and the power that it's able to do and have and how it can do things, right? So, thus, now we got the authenticated agreement. Now, authentication literally in the UCC just literally means signature, okay? A signed written document. So, authenticate includes a signing a written document when the straw man representative, okay, which would be the living man or woman, acting in authorized capacity, signs a security agreement. This condition is satisfied. So once the security interest is created, it is perfected by filing a financing statement, according to the UCC 9-502A. So now you have the debtor, which is the all caps, and now the secured party is the actual trust, and the full description of the collateral is what you also have in there. And the only thing you need to file a UCC is a security agreement. You don't have to have anything else, family. Okay? You don't have to have anything else. I'm going to say it one more time. All you need is a security agreement, and you don't have to have anything else. Okay? That's all you need. So now, this document is filed with the Secretary of State in the jurisdiction of the straw man's creation. You can put it there where the debtor may be. No judicial approval is needed. The law only requires the filing meet the content requirements of UCC 9-502 to be effective. So that means the following assets may be lawfully pledged by the straw man to the trust under the security agreement. That's all certificates, all the bonds or accounts issued in the straw man's name, all tangible, intangible personal property, bank accounts and deposits, Social Security related entitlements, all future wages and contracts, right? UCC 9-108 A supports this by requiring only that the description reasonably identifies the collateral. So a clause such as all property, tangible, intangible, now owned or hereafter acquired by debtor is lawful and sufficient. Now, once it's perfected, the trust security interest holds priority over subsequent creditors under UCC 9-322A. So what now that means is you have first in right, first in line, and you are the first in time, right? By making the claim, asserting your claim. So now, this is where they have what they call the conflicting perfected security interest rank according to priority and time of filing or perfection. So you're the only one that has perfected this claim. Nobody else has perfected this claim, none whatsoever. You can do a UCC 11 search, and nobody has perfected this claim upon the actual legal fiction but yourself when you see. Okay, so this means the trust becomes the first lien holder of the legal fiction property and may lawfully repossess or claim collateral, challenge third-party claims, issue notices of debt. So once filed, the trust secured party status is recognized by commercial database, which is the UCC, and other financial institutions, etc. Government agencies when proper notice is given, and no further permission is required from the state or federal government. Per UCC, the legal standing of the secured party is self-executing once the filing is complete. So now that literally means that you have to do everything yourself. So that's why I say just having a trust is not enough. Just having a security agreement is not enough. You still need to go know how to go out here and leverage your position. Your position is you're the one with the first in right, first in time, first in line. So that literally means nobody can get any money with anything related to the estate until you get paid first. You see what I'm saying? That's absolutely what it's doing. Dub 16. You're right. So once you learn that, you're first. Now you just have to go out there and leverage that and move like you first. So how do you move like you're first? Right? How do you move like you're first? And you see, here's the thing. A lot of you guys go out here and you do things and not understanding because you go you go try to file a security agreement or a UCC, and then you'll put the uppercase, lowercase name. And what they're doing is they're going to reject that. They're actually rejecting that because they're letting you know that that's the same entity. And they also letting you know that the United States can only deal with the legal fiction. It cannot deal with the living people. So you have to use your legal fiction, which is an avatar for you. You're controlling it, operate it. So make it grant everything to the trust, which you as the living are in control of fully at all times. So once it is in a security agreement and or conveyance and granting, et cetera, and all of that, now you're in full control. So now you just make the trust, which is its own legal entity. It can enter into any contracts that it wants to. So as a trustee, you make it enter into a contract with the legal fiction. Now you are basically doing it for, let's see, administrative value protection and suretyship to the debtor's estate and commerce. That's consideration. So that has to be the obligation that's being fulfilled. So in place of that, as collateral for in return of what the obligation is, well, now you're going to give everything in relation to the birth certificate, the Social Security, bank accounts, intellectual property, copyrights, patents, trademarks, any licenses, vehicle, land, mobile homes, real property titled in the name of the debtor, contracts, wages, future earnings, or claims, any EIN number, DUNS numbers, any identifying commercial instruments, all proceeds, substitution, the sessions, products of the foregoing. It could be on and on. But see, now a lot of you have what you trademark the name. So if you've done that, that also goes into the actual trust. So now the trust gets to go around with everybody that's using the name and saying, hey, we see you using trust property, and this is what's going to cost you. This is the invoice. You must be renting or asking. It's no difference than the people out here that are responsible for hearing someone, they get copyright, for taking people's music and doing things like that and putting it in their own without asking and stuff, like without full permission granted. Like, this is the same thing that you're having to do now out here with the trust. You got to go out here and operate the same exact way now. You have to. All right? You have to be able to do that. And that's part of the trust administration. So now you also got to understand, by doing this, now you got interest in any bonds that's going to be created in court. Now you got to ask yourself, how are you able to place that? Number one, we always send a notice of secured interest to the clerk, and then we also can always place a motion for the accounting of the case for any bonds that may be attached. And then we can do also a motion to intervene and a motion to preserve and protect the trust interest and property at all times. And see, this is the difference between knowing how to assert things public and privately. When we're dealing with the court, we have to act accordingly to the court rules. So we're going to use our motion of discovery tools. But when we start dealing with the administration of the trust privately, we'll just send it to the clerk and say, hey, this is how we doing. Here we go. Like, this is everything that I need, and I need the full accounting here. And it's also going to be placed on the record. But to the clerk, we're just letting them know the administration of the trust. And we have rights to everything. That is the main thing. Anything that we want to see, we have the right to see it. All right? But you have to literally know how to move accordingly. And a lot of people fail at that particular part. So, yes, you got to understand courts issue bonds, and they do it in the name when initiating any form of cases, right? So they have appearance bonds, performance bonds, payment bonds, appeal bonds. They got the recognizance or surety bonds, cash bonds, or escrow equivalents, okay? So these financial instruments are assets on the public ledger and often monetized, insured, or traded as negotiable instruments under commercial law. So now if you got the actual security agreement here, then you have already perfected the claim and interest of first in line. It's not that you're caring about any of it. Like, I don't care that you guys are back here doing what you're doing. Just make sure I get my cut first. I'm here first. I got first in line. Y'all can do what y'all doing. Just give me mine. In fact, I just give me 40%, man. Y'all can take 60. We'll go our way. It's just negotiation, guys. Being able to, but at the same time, still being able to control the courts according to your motions and the affidavits and things like that. That we're going to touch some things we're going to speak on a commercial aspect, just literally handling business. Other things that we're going to speak on are going to be based upon, the facts and findings of the case that we need to bring forward for our own defense and preserving the record for the appeal. That's all we need to do. That's handling that with any situation that's going to come with these courts. But my question is y'all have these trusts. Do you know this? Do you understand what you have? Yeah, y'all got security agreements. People done them for you. You have a trust. Cool, great. But do you know what to do with these things? Do you know how to operate them? Do you even understand why you filed it on the UCC in the first place? Right? And a lot of people are like, oh, well, what about the UCC3? Well, that's just if you're going to do any form of adding to it. Because if you give somebody some type of power over something, then you can go to the UCC and say that you assign them some type of right or interest over some type of form of property as an assignment. That's it. Now they're able to be down as secure party with you over that particular property interest that you assign to them. That's it. It's nothing major about it though. But at the same time, the major part is you truly understanding how to operate, family. How do you do this? Right? So filing this stuff, having this stuff is not enough. You need to understand how to intervene, file a protective motion. Also, objection to discharge of secured interest as well. You need to learn how to include your UCC filing as evidence in your affidavit, your certificate of trust, and your resolution of trustee if you are in some form of family trust that has more than one trustee. You're going to need these type of things, right, to be able to operate. So you can also, what we call, also in this class is going to have the notice of secured interest. So this is where you literally send this to the clerk, letting them know of your secured interest in any of the bonds case, any form of monetary value that's being created with the estate that you have first and right to it. So now the court's not making any money today, to be honest with you. And if you want to, you can bind it. If you want to, you can bind the case, bond the case as well. Sometimes, but you got a secured interest. You can do it that way. Sometimes I would literally take the conveyance. I will convey the case and put the whole, because the case is like an account number. So you can take that account number and use it and literally place it into the trust, give it a form of value, and literally bond the value of that account yourself as well too. And by doing that too. I mean, and it's just a little something on the private side. Like you can do it that way too. But what really matters as well, it's got to be a balance too, guys. It matters what you say in the public court and how you operate. The things you do in the private, you do not do in the public. You're not going to send notices to the court. The only type of notice that would need to go in the court is a judicial notice. So you would have a motion to enter a form of judicial notice. All right, that's it. That's the only notices. Everything else is motions, affidavits, and answers. That's it. There's nothing else to put into court. Everything else is done on the more of the private side of you doing administration with the trust. You know, that's what you're aiming for. So, and it gives you more of a leverage. So let's just say like, if we're dealing with a court case, we can do a motion. So now listen, we did a notice of secured interest privately to the clerk for her to let her know we have an interest in these things. And now we're going to place it inside on the public side, which is a motion for accounting and disclosure of commercial instruments bond issued in the name of the debtor. See that? See the difference? See how I did a notice to the clerk of a secured interest, one protecting the interests of the doing administration coming from the trust, and now we're going to place this motion also into the actual court as well. So we place this motion for accounting and disclosure of commercial instruments, bond issued in the name of the debtor. Comes now. You'll put the full name of the trustee, acting as duly appointed trustee for the living trust, a private non-statutory express trust. Respectfully move this honorable court. See, you have to move the court. You want the court to do something, you must place it in, put it into motion. Okay? So move the honorable court for an order compelling full accounting and disclosure of all financial instruments, surety bonds, registry funds, and commercial paper created, issued, held, or monetized in the name of the debtor within this case. That's what we want to do. Okay? Full. Okay, we have to, because we have to make sure that they are operating from an impartial judicial as well. And they're not operating according to the Clearfield Doctrine as a form of corporation here for profit. So this is also the things that needs to be reported to us so we can help for our proof for our defense. It's all about what you say, family. All about what you say, right? So we also got, man, there's so much in here. You need to know how to motion to intervene as a trustee. You need to know how to do that as well when it comes to trust property. But you can also leverage this security agreement, right? Can the court say no? Can the court say no to what? The court can say anything. And here's the thing. I don't have a problem with the court saying no. They can say whatever they want to. I'm just preserving the record. Because here's the thing. If you do everything that you know is right and your right of interest according to the law, then assert your right. And all you have to do is preserve the record, because when it comes times for the appellate court is only going to look at one thing, the law and the fact. When I say law, the due process of law and the facts that were placed in it according to due process of law. So when they see that, the record's been preserved. If they see they didn't give you a what do you call it? What I'm trying to say. If they see they didn't give you a particular motion, a hearing on a motion or anything like that, then now it's violation of due process. If they gave, you placed a motion in there, they didn't do that, or they didn't answer to certain things that was placed in there. But also we can go before the actual court, as I spoke on in my master appeal class, that we can actually go to the appellate court and do a writ of prohibition. We can do a writ of certiorari. We can do a writ of temporary injunction on things. Just depends on what the actual situation is. And we can do that before we ever get to the court because we want to prevent any type of harm that could actually happen. So now we're operating on the private side and we're operating on the public side. We got them either way, however they want to roll. And we're going to make sure that we preserve our record fully. All right? That's what we want to do. And in doing that, it gives you so much power. And then I also got another ebook that will go in this class. It's called Asset Protection. That and Private Administration. It's going to show you a few things as well. But again, a lot of this comes from people just not knowing, man. You got it. You got all the answers. You got everything that you need. You know what I mean? And all you need to do from there is just move forward. Move forward. You can ask the same type of questions that you placing into your notices on the private side. You need to learn how to formulate that into motions on the public side. And then being able to, now you got, it's a balance of the scale. It's both being done and it's going to hold the weight because now they're finding themselves being binded into a contract commercially. And if they go commercially, then now the actual trust has everything. So it ain't nothing they can do. If they want to go strictly to the Constitution, then majority of the time it's violation of due process of law, or like I say, it's not an impartial judicial place situation, especially traffic tickets. You guys should literally know how to get those dismissed because they are criminal procedures, and all criminal procedures have the right to a speedy trial and an impartial tribunal jury as well. Immediately, you never get that. Even if you do, if you take it to trial, they try to take you to a bench trial, stuff like that. So, just make them honor the oath. Like if they're gonna operate constitutionally, then they know what's up. They're going commercially. Well, we have first and right, first in time, because one, everything has been conveyed into the trust. Everything is under secured interest. Now you got the UCC perfecting it, showing that the trust is a secure party. You're the trustee fully operating. You're just here to protect the assets of the trust. That's it. You're just doing your obligations, you're fulfilling it. Anybody dealing with trust property, we're going to hold them accountable and make sure that we keep creating the wealth for the actual trust. Very simple method. But you got to be willing to do it, though. And you can't just be out here putting out paper, just sending out stuff and not understanding what you're sending out. So that's all I'm going to say. And if you know how to do it, you know how to do it. I've been doing this too long. And every time I've done it in so many different ways. But what I have always noticed is due process of law and just your rights and interests and knowing how to assert those things when it's time, because now you can create facts and evidence. And when you do that, just know you're going to always have that particular power to always go and make the first claim on everything. They're never going to be able to make a claim with you about anything, right? Even when it comes to mortgages, when you learn how to operate, administrate the trust, and use the security agreement, we're sending something to the mortgage company, and we're going to ask for full accounting. We want full accounting of the chain of title and everything. We want to see it all. You know what I'm saying? It's kind of like we're going to do a whole audit of the whole entire contract. And we want to know where everything is, where everything went, who got what. We need to know it, every bit of it. All of it has to be fully disclosed. So once that happens, if they do it, they fulfilling the obligations as they're supposed to. If they don't, if they choose not to fulfill this obligation, then remember, the actual secure party creditor is the creditor itself is literally subject to the claims of the debtors. So that means that if they don't fulfill their obligations, we get to call them out on it. That's also considered what you call a breach. So now we got a breach here. But again, it's so many ways that another way that we can go at this, even looking at it from this perspective, if you look from the perspective of that this is your trust, this is the assets of the trust, and they're using it. You got your name, trademark, and all of this stuff like you guys do, right? So now we ought to be literally coming from the trustee perspective, showing a certified copy of the legal title, which would be the conveyance or security agreement if you want to use that, and showing that you have secured interest in these particular things. And you want to do a set off based upon them for the use of the property. Or they have to literally give you every single, they have to give you interest within to the interest based upon the securities that they're pulling in, the money that they're pulling off of your securities, right? One way or the other, we're going to get in the door. And then you also either going to show us, prove to us legal authority, or you ain't got to go through all of that. You can just cut us a percentage of the check, and then we'll just keep it moving, and y'all have a great day. Business. That's it. Because if not, then we're going to go the other route. If we got to go the other route, it's going to cost you a whole lot more. All you had to do is just give me a little equity. Which also brings us to our class, August the 9th, that we're going to be doing with the hidden ledger. Because once you do this, you set up a trust, a non-interest bearing account. And the reason why you set up a non-interest bearing account, because you're not just agreeing to any little small form of interest when it comes to these other accounts. So when you do a non-interest bearing account, it's easier. Now you get to make your own form of common law contract for the use of the trust property. I don't care what it is. Nobody can take anything of the trust and use it and not pay the trust. All the trust has to do, because if they're going to be doing fractional reserve banking, with your money, with the trust money, let me say it like that, then the trust definitely gets to assert its equity, and they will have to pay the trust. So you might as well go ahead and lay down the rules and just say, it's in there. You can literally get your equity. Totally up to you. Do 1099Bs for the deposits that you have done within the whole entire year, but you do not have to know how to claim it. Definitely not how to know how to claim it. You have to claim it specifically right, but at the end of the day, you definitely can get it all back through a simple measures, right? But there's going to be a great class, man. Tonight, all right? Tonight, what I want you guys to do, if you're listening to me now, okay, if you're going to do it live stream, okay, and this tonight only, so that means after 12 o'clock tonight, it's over. So I want you to send me a email, and the email is admin at ingodwetrustacademy.org. Again, that's admin, ADMIN, at ingodwetrustacademy.org. Send an email and just say discount. That's what I want you to say. And I'm going to get you into the trust administration class. If you're going to do it if you're doing live stream tonight and tonight only up until 12, you can get it for $100. Live stream. So you need to make sure that you send it, put discount. Tonight, 12 o'clock, the gig is up. But this is something you guys can definitely do. And I just fully explained it to you. So now all you got to do is research it yourself or just come to class and I'll show you exactly what to do. Absolutely. Are you going to pull up on me? Well, pull up on me then. Be glad to see you pull up. For the people that's going to be in person, y'all going to get a little something extra. Going to get a little bit more extra. So a few other things that I'm going to give you guys. So if you pull up on me, definitely going to get something extra, right? So, yeah, man. So this is one of the most beautiful things, though, I like about operating the trust. Now, can I still be the court case and all of that stuff? Then yes. Yes. I can still do that. I was reading something. I had to read that, but yes, I can still do that. I can do all of that because I understand court procedures. But how do you protect your assets when it comes to that? And that's the part where you need to learn how to fully take everything and operate according to the way that you want things to be done and for the trust to help and continue to protect its wealth and interest that it has within the estate. So pull up on me and I got you. Somebody said they treat you great when you pull up. Absolutely. We're going to show plenty of love. So just pull up on me. I like the fellowship. I like to kick it. I like to rock out. So just make sure y'all pull up on me. I'm going to be explaining this though. It's more and more and more and more. And just wrapping your head around it, just so that way when you're ready and you step in class, you can have all the aha moments and boom, ask the questions. You ready? You've been doing your study before you got to class, and now class hit. You get to see all this stuff that I'm finna show you, and it's like, okay, I know what to do. It's game time. It's game time, right? So we just want to make sure that you guys know, get in on that. And as always, thank you guys for your participation tonight. I might come back in a little bit. Got a few things I need to do. Anybody got any questions though before I go anywhere? Y'all got questions? Ask some questions. I ain't ready to go yet. Let's see what kind of questions y'all got for me. What kind of questions do y'all have? No, we're not in work session season 6 anymore. We'll be going to season 7 is what we'll be doing when we open back up for that. But right now, trust administration questions. You can literally do so much with this that you guys have no idea about because, it's just understanding what you can do. Commerce, commercial world. Guys, you can take your tears and place them into trust and value them. You can create you a whole teardrop. I'll put all your tears in it. Say your tears up. Give it value. Put it in the trust. I ain't joking either. I'm serious. The conveyance. Are we conveying our equities to trust, then reconveying? Hold on. You gotta say that a little bit different. What you mean conveying your equities and then reconveying? Explain to me exactly what you mean by that. I don't know. Can I get you to come forward? Let me see if it'll let me. See if you can do an invite and come on here and ask a question. I'm gonna see if I can accept it. If it come on up there, I'll let you in, big dog. I know it be some people be doing invites. I'll let you up here though. It ain't said nothing yet. There we go. I got you up here now. Can you hear me? All right. So what's your question? Yep. Right. Well, here's the thing about them. So the question that's being asked is basically like, okay, you want me to answer the court one first? I'll answer both, but um, when it comes to the court first, the question that's being asked is basically like, can the case be bought in a way? And it's all about whoever bonds the case wins the case. So, well, you have to understand that's why I mentioned security interest, the security agreement. That alone, if the trust is a secure party and the debtor is a straw man and the trust has collateral interest in all of these accounts, intangible, tangible property, birth certificate, social security, anything that, you know, the name has interest in. Well, what that means now is that you have first in right, first in line to any form of anything of monetary value that's going to be created. It's yours first. You see what I'm saying? So now it's up to you to assert that claim. So that's why I said I send a notice of secured interest to the actual court. Okay, that'll go to, not the court, but to the clerk. All right, and that's letting her know, hey, any bonds, anything that's being created in here on a monetary value in any type of way with that has anything to do with the name here, because now most people should have if you got it what trademarked, if you got it what else you want to call it, like an also a security agreement as well. If you got those two, then you can go, you can go at it for that particular reason to claim the interest that's going to be used, right? So now once you do that, the best thing to do now is on the public side, which means inside the court, we want to make sure that we file a motion of accounting. So now what that's going to do is that's going to make them have to bring out the books for anything that's in relations to the case. You see what I'm saying? But we also need to do that with the motion to intervene. Because if you have the name trademark, a motion to intervene by the trustee, because remember, the name, the trademark and name, etc., now belongs to the trust. So now the trustee gets to intervene into a case and claim its interest and security within this particular case. So now it gets to go in and defend the asset, which is the name. The name is the asset, which is trademark that belongs to the actual trust. They in here using it without paying shit. No, somebody got to pay something. Y'all using trust property, regardless of how you look at it. Here's the evidence. You'll give the trademark, or you can also give the security agreement and place the UCC one as well on the record as evidence, and then you do a motion of accounting because now we want to see any and all things that's related. So now we need the treasury to come on out. Even if we got to have the treasury of the county, the treasury of the city, somebody finna come show something. And they finna hear him get your ass up out of there too. So that's the court side. Does that make sense to you? Yeah, that's all it takes. It's being able to do both. Because we already privately told the clerk that we have a secured interest, right? We already showed that. But that was our whole point of coming into the court side now. And when you want to come into the court, you need to be able to do a motion to intervene if it's dealing with trust asset. Right? Now, on the other side, what you was asking about, yes, all those other accounts, bank accounts, whatever, it's the same way. But remember, you trademark the name. You also have a security agreement. So you got secure interest. You perfected that with the UCC. So you're the first in right, first in time, no matter what. So now when you show up and you're saying, hey, you're using trust property here, right? So now, how many times have they sold that note and made money off of it? You get an interest in that because it's attached to the estate still, and they're making money by using the name, right? Now, me personally, I also convey my signature, autographs, and things like that as well to the trust. So that means that if they're robo signing your signature, all of that type of stuff, yeah, let me get that money too. You see what I'm saying? I mean, it's just business though. You know what I mean? It's just like if you really think about it, it's mine. You didn't ask. Let me, this is what it's going to cost. This is what they call a constructive trust. So now you owe me this amount for using my property. You made this money. Well, by equity, you must perform and give me what's mine, right? Yeah, yeah, that's exactly. So if you operate it in that particular manner, it's all in your favor. I just think a lot of people just need to slow down and think about it and just start really like, because I look at myself like, okay, in the commercial realm, we all merchants, every last one of us, right? We're all merchants, right? We got titles to all our belongings. We got this, we got that. We got value of all kind of assets over here. Like we're acting as merchants, and you want to use property, we're here to make any form of barter and exchange, profit gain, whatever you want to call it. We're here in for that particular service. But also, we also stand as the living man on the land who still operates by common law, which means we have the right of contract. You see what I'm saying? And that's also protected by the actual Constitution, which is an inalienable right. Your right of contracting is an unalienable right, right? They can never lien your right to contract, ever. So, with that being said, then I got the right to contract however I may choose and see fit. So, this is what I do. I'm just going to make sure that I operate according like a business because now you also dealing with my time. You see what I'm saying? Like, oh, y'all still like I make the trust send an invoice to the clerk to the court because it's using my time. Even though I'm coming to court, and it ain't even got nothing to do with me personally. It's just my time was conveyed to the trust. My trust now owns my time, and anytime my time is being used in certain places, this is how much it's gonna cost. Yeah, and they can't say I can't do that because it's private property. If I can sell time for through labor, then I can do it any other type of way too. You see what I'm saying? Yeah, no problem. I just try to make sure I can open up people's eyes because do we need a trust to do a lot of? No, I can still do all of this with no trust. I could do a lot of stuff. But what makes it better is a trust. The trust makes it better because it's there in the proof. Like you get what I'm saying? It's that they can't come up with a contract better than yours that supersedes you or anything like that, right? What's written and expressed is always easy to prove. But when things are verbally said, it's kind of hard to prove that. That's how it falls into what we call hearsay, right? So let's fully express it. And that's the thing about commerce. In commerce, everything has to be what? Expressed and disclosed. So if we're gonna do that in that particular manner, then let's express and expose everything. Let's just make sure that we put it out there. Because if people will act like they don't have anything to put in their trust, but what do they have? You got your time, your energy, your signature, your autograph, the print of your name. All of these things are going to be used in commerce, one way or another, right? Yeah, you can't take credit, pick it up, and move it to another spot. You can't do that. I understand what you're saying. It's not tangible. We can't grab it. We can't grab a hold to it, move it from one spot to another. So, but see, I'm glad you're saying that though, because now that need to open your eyes up to how far you need to go in taking this when it comes to commerce. Like, man, we could. What are we talking about here? It's so much stuff that we could place into the trust and give it value and leverage it and operate it. I mean, they doing it. Why not? That's the reason why these people will literally go make a painting, bro. Seriously, go create a painting, slap something on it, and then throw it into their trust. Give it a value. Once they value it at that much within their trust, it's worth that much. So now somebody will come buy it from you. Now all they got to do is create a title, put a title to it, etc., stuff like that. Do the 1099 if you want to say that they accepted something of this value into their trust. Boom, it's it worth it now. Straight like that. You see what I'm saying? And you be looking at stuff like, how is that worth anything? That's how. And now they can literally take this to the to their bank, etc., place it into the bank. The bank will write off something to them, give them a form of certificate or whatnot, saying that they have this particular asset in there and it holds this value. That's all the trust is. It's operating as your own bank. Which I did a class on that a couple weeks ago, private banking, showing people how to literally take everything you do, place it into a trust, value it, create your own form of currency, make people purchase it to receive any form of service, product, etc. from you. Everything fully tax exempt because you make them join your PMA. It's all private contract, private association type transaction. And there you go. There's no taxes, and you continue to build your wealth. You can also show proof of funding because you can show your own ledger and leverage those particular. So if you let's say you got 50 clients and those 50 clients are returning clients at least 3 to 4 times a week. All right. And you're adding each one of those 50 clients bring two people, right? And it just that keeps happening. And you create a ledger. What you think the bank gonna do when you go want to go get what you want to get? You know what I mean? They're gonna give you what you want. You can because you're proving the ability to pay. That's all they want to know. You know what I'm saying? It's the same thing with like, okay, let's say if you move, for instance, a lot of people got land. All right, let's say if you got land, one or two ways you can do this. All right, I'll answer your question in just a minute, Chelsea Crawford. Hold on. All right, so you can literally, when it comes to land, you can take your land, put it into a trust. Let's say that, and let's just say that's all you got, but you got a business idea, everything. You know what you want to do. You can take that land, place it into a trust, okay? And you can place it into the trust and you can give the benefit of that land or the use of that land, etc., to a LLC or something, right? So now that LLC gets to go and take that particular land and it gets to leverage it on what it wants to do. So let's say that you want to build I don't know, 50 apartment unit, right? 50 units. Let's say they're all 2 bedrooms. We'll say 2 bedrooms. Each one of them we'll say 1,500 a piece, right? So now, what you think the bank gonna do? And you got the full out plan, what it's gonna cost, what you need, how you want everything to look, everything. What you think the bank gonna do? They're gonna give you the money. You know why? All right, that and they understand that once you get it built and it's there, if you default on it, they get to what? Exactly. So they'll seize the property, turn around and do what? Sell it, make all their money, and you still owe them, gotta pay them, right? So now, only thing you gotta do is just make it count. Me personally, I give the bank 70-30 for so many years. The first, what, 4 years, 70-30. After the fourth year, we'll break it down to 50-50. The closer it get, the less they get. It'll get all the way, what, to the last couple of years, we'll do 80-20. Where I get 80, they get 20. And then after that last year, shoot, it's over with. I'm 100% in. By then, though, I done bought other land and building the same thing. And now I ain't even got to have the land. I just got to have the idea. Say, hey, it's some land over here. I want to buy this land here. You do it with your LLC, remember? You want to buy this particular land, right? We already showed them the play. We already know what they want. They already know what we want. Go run the play again. Here go the money. You can have it. They just waiting on you because the thing is they either gonna get paid or wait on you to default. Before you know it, 10 years later, you got up to 2,000, 3,000 something units. You see what I'm saying? Out of those 3,000, half of those are already yours, 100% in. The rest you might still owe on, but so what? It is what it is, bro. People are, and the thing is you can still be sitting on $1 million cash at home. The only thing that's gonna happen if you don't is that your company go bankrupt. Then you just sit back, wait. You can build credit up for a little while, start all over again. Still got $1 million cash sitting to the left side of you. Ain't touching none of your money. We just playing with theirs. I mean, that's what they doing, bro. That's what it is. That's what it is out here. All right, so let me answer this question for somebody. They said, I'm facing a traffic charge in Harris County Justice of the Peace Court, Precinct 1, Place 2, which already offers jury trials. In my motion to dismiss, should I still invoke my right to a jury trial, or is that redundant since the option is available by default? It's already there. So you just have to make sure you request a jury trial. Do that specifically, and now you just need to make sure that you handle everything else according to due process when it comes to the officer, whatever the case may be, uh, etc. Just make sure everything's according to the Constitution. That's all you got to do. If it's speeding, make sure that you do a motion to. Uh, you want to do a motion of production. You want to ask questions on when the gun was calibrated and all these other things as well too. If it's just many ways you can go with it. Just make sure that you fully prepared and be ready to answer those questions. Answer those questions. What's the speeding ticket for? Where do you find your case laws for your emotions? Chat be spitting out the BS. Man, most of these case laws are already been done. You can literally just go get old case laws from things that's taking place. Just put in a particular subject that you want to know about case laws and have Google pull them up. Google will pull up those particular ones that pertain it. Just go read them and No, it's two citations for not having my driver's license on hand and one citation for no insurance. Hold on. Hell, hold up. Wait a minute. How you get pulled over for no driver's license in your hand? That don't make sense. And no insurance. Where's the probable cause that led you to be in court? Yeah, where's the probable cause that led you to be in court? So you're saying it's two citations for not having my driver's license on hand and one citation for no insurance. How did we get to that point? And if the probable cause is not there, then when it comes to the jury, since you're going to have a jury trial, you have to let them know that this is fruit of the poisonous tree. If the probable cause is not being considered in the charge, it's nothing they can bring to you because they can't just like go drive down the street and say they don't got their driver's license in their hands. So that's not gonna work. What's the probable cause? So the officer was inside of my apartment complex and he followed me outside of my apartment complex and I'm guessing ran my plate and saw that I didn't have insurance. What that's got to do with anything though? You just can't run your plates just to be running your plates. So the probable cause, but he said he stopped me because I didn't have no insurance and registration is not up to date. So if the registration was not up to date, then how did you get registration? Why didn't you get a one for registration? That's all I wanted to know. Yep. I would ask those questions for sure, but I definitely would. They're not. I just don't see them giving you a. If they give you a jury trial for a traffic case, that's amazing. But they don't do that for real. They call those what they say petty offenses. That's why they give bench trials. But you ain't supposed to take them no way. But if you know, then you know. But again, just use your discovery tools on everything. I'll be asking all kind of questions. We need a motion to make sure production for the officer's bond, license and bond. We need to make sure that he's up to date and that he was operating lawfully in his capacity as a public servant on that day and has everything attained to operate on that day. If he don't, then that makes his null and void. Ab initio. Well, that's his fault. Errors don't count. Can't be charged for the same thing twice. So that'll probably be thrown out. Contact him too. I would do that. Anybody else got any more questions? What's up? Let's see what we got. What we got here. Yeah, you can do that. You can do a lot. You can ask for a lot in productions. Whatever that you want to have in productions, you can make sure it happen. But if you're interested on the things that I spoke on today, my beautiful people, there's only one thing that you need to do. One thing that you need to do. And you're going to want to go to, let me see if I can get it back. I don't even know if y'all can see me no more. Seems like they're messing with my stuff. Hey, cause I got that. How to do it? But I guess that's it though. But make sure y'all come to check out the trust administration class, guys. July the 26th. Remember tonight and tonight only. So you better send us an email, admin at ingodwetrustacademy.org, and just put discount. Okay, send us an email and say discount. Only for the night though. After 12, it cuts off. Okay. Here we go. So if you want to get in on this, it's 100 tonight. But you have to text us, email us at admin@ingodwetrustacademy.org and literally put discount. All right. And I appreciate you guys for tuning in with me and watching this with us tonight. And just know I'll catch you guys either later on when I get back on or first thing in the rising. Make sure y'all like, share, and subscribe with us. All right. Peace. Out of here.